Meta CEO Mark Zuckerberg is in a Los Angeles courtroom right now defending his social media company against allegations that it's designed its apps to be addictive and harmful to children. Zuckerberg is taking the stand as part of a landmark trial against Meta and YouTube. TikTok and Snapchat were originally part of that lawsuit, but they settled before this trial started. Now, the outcome of the trial could shape how thousands of similar cases play out. CBS News correspondent Carter Evans joins us live outside that courthouse. Carter, good to see you again today. This is the first time Zuckerberg is defending his company in front of a jury. So what have we heard so far in court?
Right. Well, he's inside that courtroom testifying right now. The first part of the day, the plaintiff's attorney spent a lot of time focusing on age restrictions on Instagram. No children under 13 are allowed to join Instagram. But as you know, a lot of kids are able to get around that. And this is important because the plaintiff in the case here, who is 20 years old, who claims that her mental health was harmed by using social media, she got on Instagram when she was 9 years old. And at one point, Zuckerberg seemed a little frustrated with the line of questioning. He said, "I don't understand why this is so complicated. We're not perfect. We have been consistent and clear with this over time. We remove them if we find them," referring to kids under 13. But then they pulled out some internal documents that showed the previous strategic goal and focus was total time spent on the platform by teens. And so this presentation that they displayed as evidence said the goal was to increase U.S. teen time spent. Summary, big bets, this is back in 2017. The fifth item was under 13-year-olds. So what the plaintiff's attorney is trying to suggest here is that not only did Zuckerberg know that kids were on the platform under 13, but that perhaps he was looking for a way to capitalize on that. Now, Zuckerberg did say earlier on in the company, we did have these goals, and I decided we didn't want to focus on time, but focus on utility and value instead. I have a basic assumption that if people find something useful and valuable, they'll use it more. That's different than a team having a goal to get people to spend more time. It's kind of a, if you build it, they will come argument, but he did point out that they do still keep track of the amount of time that people spend on the app so they can measure those metrics against their competitors. So it's kind of splitting hairs here up on the stand today.
Yeah, certainly seems like it is. Carter, we know parents who say they lost their children because of how harmful social media is. They're also in the courtroom today. What are we hearing from them so far?
A big contingent of parents, and not just here, but around the country, are watching this very closely today. They are concerned about similar issues, what they call the addictive nature of social media and the apps themselves and the algorithms that are behind them. And what they're claiming here is that it's not necessarily the content itself, but that it's the way these apps are designed that makes it addictive to children. That word is in dispute, but here's what one of the parents had to say about Zuckerberg's testimony today.
It was a very strong argument that he did not tell the truth in that congressional hearing. It does not match any of the internal documents that we are now seeing, and he's not able to answer those questions now either. And so he's fumbling over them. And we just see that as a sign of, you know, he knew perfectly well what was going on. The intention of the company was to prey on teens, use teens' usage, exploit them so they can make greater profits. And that was done intentionally, not by accident.
Now, what she is talking about is Zuckerberg's prior congressional testimony. And what trial watchers are pointing out here is that congressional testimony is different from court testimony. That's in front of a bunch of elected officials who may or may not do something with the information they receive. They may or may not follow up on any perceived bad information. This is a court of law, and there are penalties and repercussions for what is said on the stand.
Yeah, we'll see how this all plays out. Carter Evans, thank you so much for your reporting. Now let's bring in Jacob Ward, a technology journalist and host of the RIP Current podcast. Jacob, thank you so much for your time today. I want to start with what stood out to you so far from what we've heard, and also you have additional reporting about Zuckerberg's entourage wearing Meta glasses in that courtroom.
Yeah, maybe we should start with that, Mugo. It's an extraordinary, I would say, misstep by the company. They, for some reason, thought it'd be a good idea for the entourage going in there. And if you want to show that footage again, feel free. Yeah, these guys, you'll see the woman there who passes in the foreground. Then there's a guy who's going to come into the frame on the right. They're wearing the Meta glasses that have cameras built into them. And as you know, Mugo, you're not allowed to film inside that courtroom. And so the judge, Carolyn Kuhl, upbraided the Meta team and said, if you guys have recorded anything, you have to dispose of it, or I will hold you in contempt. That can't have been a good look for this for Zuckerberg going in. So, you know, your question here, what have we seen so far? I mean, for me, the thing that's so notable here is, you know, as Carter mentioned, and as that mother mentioned, right, we've seen Zuckerberg testify in front of something like a congressional subcommittee before. And those are highly performative, highly scripted, and very disorganized proceedings where there's no real discovery, there's no real documents presented. It's a lot of, you know, senators performing for the camera. In this case, you have real discovery. We have an enormous number of documents. And so he's going to his talking points, and then again and again, the plaintiff's lawyer is able to point out to him, but you do have this email here that says that your company goal was time spent, or here is the part of it where it says internally that you're you know, that there was harm being caused here. Here's where your internal documents say that 4 million kids under the age of 13 are probably on here. You know, all of that stuff is something he's never really had to face before. And so I think this is going to be a pretty grueling period of testimony for Mark Zuckerberg here, Mugo.
Yeah, I have to say, wearing those Meta glasses just seems so tone deaf in light of what this trial, this case is about. Just doesn't make sense. Okay, Jacob, some are calling this trial social media's big tobacco moment, but the defense argues problematic use is different than clinical addiction. So we spoke with an addiction expert, Dr. Courtney Blackwell, about what that research really shows. Let's listen.
From the research standpoint and our research, it's inconclusive. There is no conclusive cause and effect of social media causing youth mental health problems. We do know that young children, and especially teenagers, may be more vulnerable to some of these social media, thinking about likes and getting likes and posting and being a little bit more risky on social media. So we know that, but we don't know that it definitively causes different mental health conditions.
So, Jacob, just based on that, do plaintiffs need to demonstrate, what do plaintiffs, I should say, need to demonstrate in order to actually win this case? Because that is kind of a good point.
Well, there are two things to think about here, right? The first is this company has, like all social media companies, enjoyed the protection of what's called Section 230, which is this obscure federal provision that is basically the get out of jail free card for social media. It allows them to basically say they are a neutral platform and they're not responsible for the crazy stuff that you and I post on their platform. Then there's that argument. Then the other argument is there an actual causal connection between the use of social media and the mental health crisis grabbing kids right now? Well, as your expert there points out, it has not been proven in any kind of conclusive way in a scientific sense. But what we are going to see in this courtroom, and what we have already seen, is that internal research at the company described the harms that could be done here, including, you know, the harm of young girls using a filter that imitates plastic surgery and shows you what you would look like if you'd had plastic surgery. You know, places in which an internal report at Instagram circulated inside the company said these kids are weaponizing our functionality. They're cyberbullying one another. You know, there's all kinds of harms that are documented inside the company's documents. And that is, of course, why this is called the big tobacco moment, is because it's those documents and the possibility that they might prove that this company knew in advance that there were harms and went ahead and shipped this stuff anyway. That's the thing that the plaintiff is going to be driving at, and that's why this could cost this company, you know, billions of dollars and rewrite the rules for social media for all time ago.
Yeah, and I'm glad you said that, because if Meta and Google are found liable for harmful design decisions, what kind of precedent would that set? What would it mean for the companies, and how would it basically just change how apps are used? And honestly, the money they make too, because I assume this advertising and all of that plays into why they design their apps the way they do.
The essence of the case here, and the reason that Meta is taking it so seriously, is that it is truly an existential threat. They have actually said this in the past in filings of other lawsuits in which Section 230 was brought up, where they basically say it can be an existential risk to the company if Section 230 protections don't apply. And in this case, we know that Judge Kuhl has said you, the jury, are allowed to consider design liability. That's a whole new thing. So not only is this an abstract precedent that we're setting here, Mugo, it is in fact a very real precedent being set, because this case is what's called a bellwether. It is actually a consolidation of precedent for what are supposed to be about 1,600 other cases. This is hundreds of families, hundreds of school districts. This is districts, attorneys general from different states. There is a long line, a fire hose of lawsuits coming at this company. And so how this one goes will determine whether those can go forward and what kind of damages they might be able to claim if they win. And so this absolutely is, there's the monetary threat here, but it is then the supposition that this could actually prove that design is the problem, that you're not allowed to just claim Section 230 protections, but your design could get you into trouble. That is a total game changer for this industry, Mugo.
Wow, I'm sure a lot of people, especially parents, are really paying close attention to this case. Jacob Ward, thank you so much for your insight today. We appreciate it.